Hello, my name is Brant Hunt, and my channel is Discerning What is True. So, what I'm looking for always is discerning what is true out there. And tonight, I'm going to be reading from the book called Woe Unto Lawyers by Fred Rodell, chapter 3, that is. And since it's a good evening, that is, got some time here. So, let's do this particular video. So, let's get into Woe Unto Lawyers, and the chapter name is The Way It Works. And there's a quote here at the very top here from him saying, "The lawless science of our law, that codeless morale of present, that windows that sorry, let me start over. The lawless science of our law, that codeless mirror of precedent, that wilderness of single incidents." Albert Lord Tennyson. In order to demonstrate up to the hilt that the whole of the law is a hoax, a balloon, a lot of empty words, it would presumably be necessary to take each principle and sub-principle and counter principle, that is, of the law and turn to divest each one of its dazzling legal trappings so that the non-lawyer could see that there was nothing inside of any of them. Plainly, that would be impossible. The lawyers judges alone turn out each year hundreds upon hundreds of books full of nothing but refinements of the law and its principles. Tremendously libraries overflow with volumes which are not even about the law, but which are part of the law. That is, the lawyers, incidentally, spend most of their working lives trying to make a small dent in the mountain of literature that helps make up the law. Yet it may perhaps serve the general deflating or disrobing purpose to take the legal pants, step by easy step, off a few simple and entirely typical example of the law in action. The field of law known as contracts, and one of the most settled, most venerable, at least politically complicated fields of law. It is the field of law that deals with the agreements, business of otherwise, that men or companies, but companies, remember, are nothing but men to the law, make with each other. Those agreements usually consist of one man promising to do one thing, such as to dig a ditch, or another man promising to do another thing, such as to hand over $50. Of course, if men could be trusted to keep their promises, there would be no excuse for a law of contracts. But then, if men could be trusted to act decently in general, there would be little need for law of any kind. Correct. As a matter of fact, only gamblers trust each other to keep their promises, for the law would not stoop to enforce a gambling agreement or bet. The whole law of contracts is based on the idea that men in general cannot be trusted to keep their promises. And around this area of mutual mistrust, the law lays down its principles. The first principle is that before you can have a contract that the law will uphold, you must have an offer by one party and acceptance by another party. Only the law insists on making a party out of a single person. What then is the first place? It's a legal offer. It's something quite different from an ordinary non-legal offer, in the sense that the man in the street might use that word. A lawyer would scoff at the notion that most offers were offers, you see. For instance, if a man says to his gardener, "Tony, I'll give you $50," that is not a legal offer. If a man says to his gardener, "Tony, I'll give you $50 if you dig a ditch for me," that is not an offer either. But if a man says to his gardener, "Tony, if you dig a ditch for me 2 feet deep and 3 feet wide, running from the northwest corner of the house to the pig pen, finish it by Wednesday week," that is, through the law, would frown on such colloquial phrasing, "I'll pay you $50 when you get it done." That is an offer. And incidentally, if Tony says, "Okay, boss," that's a full-fledged acceptance, which in reality simply is also a contract, you see. What it is that makes the third proposition a legal offer, whereas the first two were not, briefly, is the fact that it is definitely enough so that when Tony says, "Okay, boss," the boss knows, and Tony knows, and most importantly, any judge would know exactly what Tony was expected to do. Of course, the whole question of whether something is an offer or isn't an offer is based on the assumption that Tony and his boss may someday end up in court over their conversation. And on that basis, it seems fair enough to say that if Tony promised to do something definitely, he made a contract, which means only that a court will hold him to his promise or soak him for breaking it. And if he did not promise to do something definitely, he did not make a contract. But the phony part is just the way the law brings into the picture one of its irrelevant generalities. Here, the abstract idea of a legal offer in talking about and dealing with a simple business arrangement. And Tony and his boss would ever get into the court over the undug ditch. The law of the case would be solemnly stated like this: the proposition was definitely, therefore, it was a valid offer. Therefore, once it was accepted, there was a valid contract. Therefore, Tony must dig or pay. Or else the proposition was too indefinite. Therefore, there was no valid offer. Therefore, there was no contract. Therefore, Tony needs no do nothing. The point is that the question of there being or not being offered is utterly nonsense. The whole business could be reduced very simply to the proposition was definitely, therefore Tony must dig or pay, or the proposition was indefinite, therefore Tony need to do nothing. But of course, to simplify legal reasoning even to the smallest extent would make the case immediately much more comprehensible to the non-lawyer and would leave the lawyers with no special mysteriously lingo in which to discuss a simple little problem. Moreover, it would leave the law out of the picture. The law remembered is that before you have a contract, you have to have not an offer, not even a definite offer, but a legal offer. To get back to the ditch, suppose Tony, instead of saying, okay, boss, had said, I'll dig him for $60, boss. And the boss had then said, okay, Tony, the average man will say that they have come to terms, and if the law enforces that kind of a thing, that's fine. The law would enforce it all right, but not in those words. To the law, Tony comment would first have to be counter-offered, involving an implied rejection of the original offer, and the boss's okay would then become acceptance of the counter-offer. And if by any chance the boss had come back as Tony would, how about 55, that would have been a counter-offer involving an implied, etc. It takes 3 years to get through law school, you see. The acceptance of an offer is not always so simple as okay, boss, or okay, Tony, either. For instance, the boss might have described the ditch he wanted and how much he would pay for it, and Tony might have said nothing, and then the boss might have set out for the 8:20 train, leaving his offer as it were hanging in midair. 3 days later, he comes back and finds the ditch all dug. Does he have to pay the $50 to his offer for it? Any more, one would say, of course he has. Of course he does. But why? According to the law, apparently there was no acceptance, and you can't have a valid contract without acceptance. And maybe this time the boss has decided he doesn't want to dig the ditch anyway, or that $50 is too much to pay for. The law slides out of this one neatly and easily, you see. The digging of the ditch, says the law, amounts to acceptance. Now the digging of the ditch amounts to the performance too, another, and more or less obvious, legal concepts. But that does not stop it from being acceptance at the same time. And if the law could not find acceptance somewhere, there would be no valid contract, and Tony might never get his $50, which would be obviously silly, just about as silly as looking all around for acceptance before you see to it that he does get paid. Suppose, though, that when the boss gets home, Tony has dug not the whole ditch, but half of it. And the boss then says, I don't want the ditch, and I won't pay for it, so don't finish it. And Tony says, but boss, you promised, and proceeds to finish the ditch and sue for his $50. The court will then settle down to deciding under the law not whether it was fair for the boss to take back his promise after the ditch was half dug, but whether digging half the ditch did or did not amount to acceptance of the offer. For before Tony gets paid, the court must find a valid contract. Before it finds a valid contract, it must find acceptance. Probably Tony would get his $50 if he had dug half the ditch by the time his boss had backed down. But if Tony had only shoveled a few spadefuls of earth by the time his boss got home and said, what is it? But if Tony had only shoveled a few spadefuls of earth by the time his boss got home, he said the ditch wasn't wanted. Those few spadefuls would never amount to enough acceptance to satisfy the court. Thus it becomes apparent that somewhere along the ditch's projected course, somewhere between the start and the finish of the job, the law, stooping to earth, first finds a magic line. Then if the boss catches Tony 1 inch or one side of the line, the law would intone no acceptance, no contract, no $50. Whereas if Tony is 1 inch on the other side of the line, the law would intone acceptance, contract, pay up. But neither the law nor any lawyer can ever tell you in advance where that magic line is. A lawyer can only tell you what the law is. The law, you may remember, is that you have to have the acceptance or of an offer before you have a contract. Another great abstract concept in the law of contracts is something called consideration. There has to be consideration as well as offer and acceptance and a number of other solemn spoken legalism before a contract is good in the eyes of the law. Putting it very roughly, consideration generally means that a contract has to be two-sided. Each party to it has to have something given him or is promised him or done for him in return for what he gets or promises or does. In l'affaire Tony and Boss, the consideration for Tony's promise to dig a ditch was his boss's promise to pay Tony $50. And the consideration for the boss's promise was in turn Tony's promise, or if Tony didn't promise, the actual digging of the ditch became the consideration. Thus, a common or garden digging of a ditch can be dignified by the law into acceptance, a consideration, and a performance, all at the same time. Theoretically, the purpose of insisting on consideration is to see to it that a contract is a fair bargain. Actually, however, the law time after time finds consideration an extremely unfair bargain and fails to find consideration where the proposition looks relatively fair. If a man says to a panhandler, "I like your face, so tomorrow I'm going to give you $1," there is no consideration for the promise, and so there is no contract, since the law does not take such aesthetic values into account. But if a man says to a panhandler, "If you give me that cigarette in your hand, I'll give you $100 tomorrow," and the bum hands over the cigarette, then there is consideration for the promise, and there may well be a valid contract. And if there were enough witnesses to the transaction who would swear to it in court, the panhandler may even get his $100. But the law of contracts rarely pays attention to surrounding circumstances. So far as the law is concerned, a man offered to pay $100 for a cigarette and got the cigarette. For all the law knows, the two men may have been lost in the middle of a desert and the cigarette their last smoke, or the cigarette may have belonged to Franklin Roosevelt, or may have been autographed by Babe Ruth. At any rate, someone offered $100 for it and got it. And a cigarette, or a match for that matter, can be pretty good consideration even for a promise to pay $100. Now, a good half of the voluminous laws of contract is concerned with what is good consideration and what is not good consideration. As a matter of fact, once offers and acceptance and a few other little things are out of the way, the whole question of whether a court will or will not uphold a promise comes down to a question of whether there was or wasn't good consideration for it. At least that is the legal way of putting it. But a non-lawyer, untrained in legal logic and trying to find a definition of consideration that makes sense to him, might well put the whole business completely in reverse. He might say that so far as he can see, consideration is what there is when a court upholds a promise and what there isn't when a court refuses to uphold a promise. In other words, the whole question of whether a court is going to say there is consideration or not comes down to a question of whether the court is going to uphold the promise or not. And though to a lawyer such a notion would amount to blasphemy, there is no doubt at all that from a practical standpoint, the apparently naive non-lawyer is exactly right. For example, suppose a coarse girl, that is, has two wealthy admirers. One of them promises her a fur coat for Christmas. The other promises a diamond bracelet. On Christmas Day, the fur coat arrives, but the bracelet doesn't. Can the coarse girl, do you suppose, go into court and sue for the bracelet and get it? On the theory that the first admirer promise of the first fur coat was good, consideration for the second admirer promise of a bracelet. Briefly, she cannot. And the whole idea of taking two promises made by separate people to a third person and calling one of them a consideration for the other sounds, of course, utterly fantastic. Yet, suppose the two admirers frequently not only the same girl, but the same church. And suppose the church was putting on a subscription drive for funds, and each man agreed to contribute $1,000. And the man who promised the bracelet paid up. But the man who gave the fur coat did not, presumably because he could no longer afford it. Accord to. Could the church go into court and sue for the $1,000 and collect? Briefly, it could. It could, moreover, on the theory that each of the promises to pay $1,000 was good consideration for the other one. A cynic might explain all this on the grounds that the law approves of gifts to churches and does not approve of gifts to chorus girls. You see, the cynic would not be far wrong. Certainly, this strange doctrine whereby mutual promises to give money to worthy causes or consideration, good legal consideration for each other, develop out of nothing more complicated than a desire on the part of the courts to keep people from welching on such promises. The law, in order to uphold such promises, had to find consideration somewhere and find it. Or, as the naive layman would put it, consideration was what there was when the courts wanted to uphold a promise and what there wasn't and isn't when the courts just plain don't care. Perhaps the strangest of the many things that the law lumps together as amounting to considerations for a contract is a seal on a piece of paper. A man can write down, I, John Doe, promise to pay Richard Rowe $500 on the 1st of January and sign it and give the paper to Rowe and will still never pay a cent, provided Rowe cannot prove that Doe got something, some consideration in return for the promise. But if Doe drops a blob of sealing wax, next to his signature and makes a mark in it, or if he just draws a circular squiggle by his name and puts it in the initials LS, which are the abbreviation for Latin, and therefore legal words for seal, then Doe will have to pay. He will have to pay even though he got absolutely nothing in return for his promise. He will have to pay because the law long ago decided that a seal, real or imitation, attached to a promise amounted to good consideration for that promise, despite the fact that the man who made the promise puts the seal there. This, of course, is a long way away from the original idea of consideration as something given to or promised to or done for the man who makes the promise. The law the law excuse may be to the effect that no man would be fool enough to seal a promise unless he were going to get something out of it for himself. Yet it happens that the seals were first used on contracts as X's, might be used today, a substitute for the signature of those who could not sign their name. And so the law, in honoring the seemingly solemnity of a seal, is in effect making a stupid substitute for a signature worth more than the signature itself. It is also saying, as our naive layman would put it, the law wants to uphold promises with seals attached. Since the law cannot find any other consideration for such promises, it will just treat the seals themselves as consideration and let things go as that. Without piling up examples any further, it is then apparent that consideration can mean the digging of half a ditch, it can mean a cigarette, it can mean a promise by a total stranger to give money to a church, or it can mean a piece of sealing wax on a sheet of paper. Yet it's also apparent that none of these things has the slightest conceivable relation to any of the others. And the list of unrelated things that lawyers may label considerations, or that judges have labeled considerations, runs literally into the millions. The point is that the so-called concept of consideration is both meaningless and yet useless until you know every one of the countless facts situation about which courts have said, here there is consideration, or here there is no consideration. But once you know all those facts situation, what has consideration become? It has become an enormous and shapeless grab bag, so full of unrelated particulars that it is just as meaningless and just as useless as it was before. The same mass of particulars might just as well be lumped together and called infatuation, or amskuglu, or bingo. Any of these words would be just as helpful as the word consideration in trying to solve or guessing how the courts will solve any new problem and that comes up, which is, after all, the sole legitimate function of the law. The new problem itself will involve a set of facts. That set of facts will look something like other sets of facts is about which the court has intoned consideration. It will also inevitably look something like other sets of facts about which the courts have intoned no consideration. Until a court intones consideration or no consideration about the new problem, no lawyer in the world can know whether this new set of facts belongs inside or outside the consideration grab bag. What is true of the word consideration is, moreover, equally true of the words offer and acceptance, and of every so-called concept of the law of contracts. It is equally true of every so-called concept in the law, period. For no legal concept means anything or can mean anything, even to a lawyer, until its supposed content of meaning has been detailed, in terms of its precise practical application, right down to the case that was decided yesterday. And once the concept has been so detailed, it is in the details, not the concept, that matter. The concept, no more than a word or set of words, is a stray vocabulary of the law, might just as well be tossed out the window. Thus, the layman who would have defined consideration as what there is when a court upholds a promise and what there isn't when it refuses to uphold a promise is absolutely right. Consideration in every other so-called concept or principle of the law amounts to a vague legal way of stating a result, applied to the results after the result is reached, instead of being, as the lawyers and judges stoutly pretend, a reason for reaching the result in the first place. By the use of these concepts, that is, the lawyers bewildered the non-legal world and too often themselves into supposing the law and its rulings are scientific, logical, and foreordained. Yet no concept, a combination of concepts, or rule build out of concepts as all legal rules are built, can of itself provide an automatic solution to the simplest conceivable human problem. Like the symbols on a doctor's prescription, that is, it can provide no more than the impressive after decision description of what the judge has ordered, and what the judge has ordered is the law. Now, a super intelligent and super outspoken lawyer or judge may occasionally admit that his legal brethren are either fools or liars when they claim that the words and concepts and principles of the law are any more than statements or results in legal language. But the same rare members of the profession will probably go on to the defense, the vast vocabulary of the law, the considerations and malices and domiciles, and all the rest, so on the theory that it provides at least a sort of legal shorthand, a convenient medium in which lawyers can talk to each other about their trade. When one lawyer that is discussing a case at a cocktail party, as lawyers always do, shoots interstate commerce or privileged communication as a fellow member of the bar with that well-known air of studied nonchalance which children affect which children affect when talking pig Latin before their elders, the second lawyer has a general idea of what the first is talking about. So too does a judge get a general idea which way the argument is drifting when a lawyer tosses off a legal phrase in court, and when the judge in turn packs his opinions with such phrases such as the lawyers who read those opinions get, if nothing more, a vague sense of trading familiar ground, shorthand, if you will, though it is shorthand which all too easily becomes unbearably long-winded, as anyone who has ever tried to read a lease or a statute or a judicial opinion well knows. Yet, it's precisely out of the constant and careless use of loose craft lingo that lawyers' blind faith in the sacredness of words has grown. Meticulously trained in the mumbo-jumbo of legal concepts, subjected to its every minute or of their working lives, law boys passionately believe in the words they have learned to use. To them, the due process of law is not just a handy way of referring to a bunch of old decisions, it is a fighting principle. And even such legal levities as covenant running with the land or estate and fee tail takes on substance and dignity. Nor is it only the plant or ordinary lawyer who takes their funny words and their word makes abstraction seriously. So too do the lawyers who have been canonized as judges. Most judges are more likely than not to suppose when they order a payment made because there was consideration for a contract, that they had actually reasoned from the abstract to the concrete, that the unearthly concept called consideration has actually dictated their judgment, as though the abstraction, consideration, had substance, that is, meat and body, as though it were possible for the human mind to pull a specific result out of an abstract concept, like a rabbit out of a hat, without first knowingly and unknowingly putting the result into the concept so it can later be found there. A court will solemnly purport to decide whether Tony is going to be paid for digging a ditch on the basis of whether there was a consideration to support the contract, just as though The idea of consideration contained within itself, like a command from God, the right answer or any answer. A court will solemnly purport to decide that the state of New Jersey may not regulate ticket scalpers for the reason that the sale of theater tickets is a business not affected with the public interest. A court will solemnly purport to decide that the federal government may not supervise wages in the coal industry on the grounds that those wages have only an indirect effect on interstate commerce. In brackets, that is, and then the same court will solemnly purport to decide that the federal government may force a steel company to deal with a union on the ground that steel wages have a direct effect on interstate commerce, as though in each case the legal phrase used were anything more than a circumstantial locus statement of the result, rather than a reason for arriving at it. As though in any case, any abstract legal phrase could conceivably contain the right key or any key to the solution of the concrete social or political or human problem. Dealing in words is a dangerous business, you see, and it cannot be too often stressed that what the law deals is in words. Dealing in long, vague, fuzzy meaning words is even more dangerous business, you see, and most of the words the law deals in are long and vaguely and fuzzy. Making a habit of applying long, vague, fuzzy, general words to specific things and facts is perhaps the most dangerous of all, and the law does that too. You can call a cow a quadruped mammal if you want to. You can also call a cat a quadruped mammal too. But if you get into the habit of calling both cows and cats quadruple mammals, it becomes all too easy to slip into a line of reasoning whereby, since cats are quadruped mammals and cats have kittens, and cows are also quadruped mammals, therefore cows have kittens too. The law, you may remember, calls both cigarette and sealing wax consideration, you see. So that's the end of chapter 3 tonight from the book Woe Unto Lawyers by Fred Rodell. So I wanted to share that with you. It's amazing. Again, he's Fred Rodell was a professor of law at Yale University, or maybe Yale Law School, maybe I should say. And he was frustrated even back in the early 1939 to write this book because he saw what was going on. He was already seeing what was actually taking place with lawyers. And a lot of this has to do with what I've been reading, also the rape of justice, connecting it with, is that lawyers are getting more and more involved in things they don't have any business involved in, you see. And this is a scary notion, you see. And so I was trying to say something about the rape of justice here. With Felix Frankfurter and others began to corrupt the law in the early 1900s. And a lot of this happens to be under Woodrow Wilson's administration. I've done videos of Woodrow Wilson earlier, not in my live ones, but actually maybe 2 or 3 years ago. I didn't know this about Woodrow Wilson, about this whole issue about lawyers and all this type of thing, and putting certain people in the positions. Woodrow Wilson was a scoundrel, folks. He's by far one of the worst presidents we've ever had. And I keep saying that because I want you to drill into that. And I want you to look into books by that are talking about Woodrow Wilson, because you need to search it out yourself also. Because Woodrow Wilson was a man who could be bought anyway and every way. He had no backbone in anything at all, except he being a progressive. He was pushing his own agendas that was socialist, and also towards communism, so to speak, too. But it seems as though he rebelled from his Southern background. His father was a preacher who was a preacher in Richmond, Virginia, and then eventually moved to Augusta, Georgia, to become the preacher there at First Presbyterian Church, and then eventually to move on to Columbia at the First Presbyterian Church in Columbia also. Apparently, something went awry, because Woodrow Wilson is not, maybe his father was not what we call a true pastor of truth itself, maybe he was a false teacher himself. And that might have had an effect, although I believe that Woodrow Wilson himself must have rejected what his dad was teaching, you see. And he went completely to the other extreme, you see. And is, you know, just read some things about Woodrow Wilson. Look into what type of person he really was. Um, he catered to his own ego a lot of times. Basically, he didn't know a whole lot. He had other people around him basically steering him in the way they were going to steer him. And he just simply did not see it, or he just was caught up in the whirlwind of his popularity, so to speak, with these people, because they must have puffed him up, make him feel like he was a superior person, when in reality, he was quite inferior as a leader. Okay, so thank you for being here tonight and appreciate it. Again, this was Woe Unto Lawyers by um, Fred Rodell, and this is chapter 3 I was sharing. We'll get into chapter 4 in the next few days, and we'll continue to share more about the law, especially from Eustace Mullins and also from Fred Rodell. Thank you for being here. You have a good night.